It's now officially 9 o'clock. Welcome to another session here of oral argument via Zoom for the 5th District Court of Appeal. I'm Judge Jim Edwards. I'll be presiding. With me are Judge Eric Eisnagel and Judge John Harris. And we have one case on this particular session. It's case number 22-476, Douglas McCall versus the state of Florida. You'll see in one of the panels here a clock with a time on it. That's the total time you have. When the yellow light comes on for the appellant, that means you're getting into your rebuttal time. And when the red light comes on, it's time to stop. We typically reserve 5 minutes for you for rebuttal. If you'd like some different time other than 5 minutes, just let us know and we'll take care of that. I'll try to remind you if you're getting into your rebuttal time and not necessarily aware of that, so that you can budget your time accordingly. If you've got anything that might make noise or vibrations or whatever, make sure you turn it down, turn it low, put it on mute, whatever, so that it doesn't ring in the middle of the session. And with that, we will go forward. Mr. Hatfield.
Good morning, Your Honor. I want to thank everyone for allowing the First Amendment initial brief, and also thank Mr. Bradford for his assistance in with correcting the references to the record that brought on that First Amendment initial brief. And therefore, the initial brief of appellant focused on confusion over the applicable and conflicting procedural rules during which there was an abandonment of Mr. McCall's constitutional right to a fair trial, and that is proof beyond a reasonable doubt. The brief focused first on the court's acceptance into evidence of a prior sworn video of a recorded accusatory statements known as States K-13, but the court denied as impeachment evidence the subsequent sworn video recording recantations in the same medium, which was Defense Exhibit A, that was not allowed. The first was taken while the participants were subject to absolutely no rules or other judicial authority or supervision. The second was at least taken pursuant to statute and the rules of court after notice, and with the state and its entire support team present. Rule 3.220H specifically sanctions its use for impeachment. Second, the brief.
Well, the rule says you can use the deposition for impeachment. It doesn't say you could use a video of the deposition, right? I mean, the court allowed your client unfettered, unrestricted use of the transcript of the deposition in impeachment.
Well, Your Honor, we argue in the appellate brief that it is not enough just to have the witness admit that she gave other statements, that the impact was totally lost because there was a video available which could have been placed in the same medium and had a better impact, that she had given completely different statements which were recantation of the touching. And the second matter that we focus on is the misconduct of the state in its rebuttal closing arguments. And we feel those are extremely prejudicial to us, especially when the assistant state attorney, knowing that the defense had no argument further, that she would begin to testify and bolster the evidence of her witnesses and absolutely deny the recantations in front of the jury as an official of the court, when in fact the recantations are clear in the record and admitted. So the reply brief focused on the prejudice to appellant of keeping from the jury the witness recantations of the video deposition, as I've just argued, and the misconduct of the state in its closing, but it also focused on the obvious fact that neither of the conflicting statements were supported by credible, competent, corroborating evidence, which is necessary. The conclusion then is that it is error for the court to disallow defendant's Exhibit A, that the error was prejudicial to the appellant and denied him a fair trial. The state's closing rebuttal arguments further prejudiced the appellant and denied him a fair trial. But for these errors, it cannot be said that the appellant would not have been acquitted. Finally, the reply brief reflects on the entire record on appeal, concluding that the trial record fails to show sufficient, competent, corroborating evidence of guilt necessary to sustain a criminal conviction. Once the jury was excused, appellant moved for an acquittal notwithstanding the verdict, which was denied. Critical to this appeal, sir, is that the CAC statements, K13, and the defense deposition statements, defendant A, are inconsistent sworn statements in the very same medium. Therefore, neither will ever become consistent, nor can either conflicting statement ever become reliable without competent corroborating evidence to support its reliability. That is the only way under the cases we've cited that this case could be rescued. There is no such corroborating evidence in this case. And so going to the First Amendment brief, Your Honor, we lay out the underlying law that we have stated that relate to this case. And I will just simply say, and not burn up a bunch of times reciting the record, which I know that you have seen, is that we've got a child who initially meets with a private organization, this Children's Advisory Group, and has a professional interrogator. And even in that meeting, the child waffles and on her testimony as to what has happened. First, in the trial, her mother gets on and testifies that she initially denied any of this touching. And it was only after she was compelled, basically, to make these statements she made them. The first opportunity that child had to recant was in the sworn deposition, defendants A, and that is when she completely recanted. She said that she was not touched, specifically not touched with the vibrator. As it relates to this business about riding this four-wheeler, I pleaded with the court in the brief to please look at, even with the professional interrogator from CAC interrogating her, trying to get her to say something related to the touching on the four-wheeler. All that was happening there was she was recklessly operating the four-wheeler.
Counsel, I'm sorry. What does this line of argument have to do with the arguments raised in your brief?
Yeah, it has.
You've lost me. If you could please connect it to the brief. Thank you.
Here's what we're saying to connect that to the brief. There are numerous inconsistent statements and recantations that were denied by the prosecutor in her final closing argument. Those recantations are there. There is inconsistent statements, and therefore the burden shifts again to the state to show competent, substantial evidence that would support even that a crime had been committed at all. That's what we are trying to say here. That's the requirements of Moore, I think, and it's the requirements of Bieber, and it's the requirements of Green, and the other cases cited. That's what I think it has to do with it, sir. Do you have a further question, sir? Are we on?
Yes, we're on. We can hear you. You can go ahead.
I'm sorry. All right, going on with the brief is that when we get to the prosecution's prosecutorial misconduct, we have argued, and it is clear to me that the state attorney was really bulldozing hard in the case, and she began to testify that the child never recanted, that she was vouching for her witness's credibility and her capacity as an officer of the court. She cooked up a fact versus fiction argument that Mr. Stack had simply made up everything and that Mr. Stack was referring to some kind of a conspiracy. That he made a big comment about attacking the government. None of that is corroborated by the record, and it violates the rules articulated in Cardona, which is cited in our brief. And so it is imperative to me for this brief to understand that those two issues really control our initial argument. But in the final analysis, I don't know where I'm, oh, I got plenty of time. In my final analysis, sir, when you go back and examine the entire record, which I did once we got the state's brief, the record has no evidence that is competent to corroborate that even a crime was committed. And
Are you, when you make that statement, are you discounting entirely the victim's testimony?
This case, it rests entirely, sir, on the testimony of this child that was first made to her mother, which she had first began saying he never touched.
Well, I understand. I understand the inconsistencies, and I understand why that concerns you. But at trial, didn't the victim testify to the various occurrences which would support the conviction?
She testified to it, but the problem with her testifying to it, it is uncorroborated by any other evidence, and that she was in.
Counsel, how did she, didn't the victim know about the thumb drives and what was on the thumb drives and where they were located?
The victim testified that these thumb drives for which the defendant was acquitted, sir, were in the Grandma Vicky's drawers, Grandma Vicky having been deceased for some years.
Mm-hmm.
That also is where this vibrator was kept, which she went back to look at. The only reference I recall related to her seeing the issues in count 2 and 3 were on her own computer. And those computers, there was no evidence at trial of those references. So apparently the person who analyzed the computer, her computer found none.
How did they find the thumb drives?
And well, the thumb drives were matters of on the 48 counts for which the defendant was found.
But I'm just asking how they found them.
Sir?
How did they find the thumb drives?
They were given to them, I think, by her mother.
How did the mother find them?
She went to where the child had said they were located, and they in Grandma Vicky's drawers. And the child was accustomed, the record would show, that of playing in the bedroom there with her deceased grandmother's shoes, her clothing, wearing her clothing, and just going around with as being what young girls will do. So that's all. That's why I assume that the jury found the defendant not guilty as it related to those thumb drives and stuff. There was no competent substantial evidence there either connecting the defendant to that.
Right. This appeal isn't about that. I was just asking how they were found.
I just wanted to respond to
yeah. I'm sorry.
I'm just trying to respond. They were found.
Very, very good. So other than you obviously are making the argument that there's a lack of credibility to the testimony at trial, right?
Absolutely.
Okay. Isn't that a question for the finder of fact as opposed to this appellate panel?
Not in the context that we have the chief evidence of the defense not in the record. And that relates to my citation in the brief to the instructions that were given by the court, which are standard Florida instruction. But if you look at the instructions, they tell the jury, if they infer the way this case was managed, that they could not even consider the recantations because they were, the defense exhibit A was not allowed into evidence. And therefore, they had testimony that there was recantation, but the actual recantation was never seen by the jury. They went in blindfolded to the
Yeah,
jury.
no, I understand. Your argument is that the victim's admission on the stand of the prior inconsistent statements, that's not enough. That you were entitled to present the video evidence of the actual inconsistent statements itself. That's your argument. I understand, correct?
Yes,
Okay.
sir.
So in other words, it's not enough that the witness live in front of the jury admits to the inconsistent statements.
I don't think that is, that I do not believe, put it in the affirmative this way, that had that jury seen those recantations of her looking into the camera with the state's attorney, her counselor, and the state support staff, and answering these questions under oath after notice, that she recanted. And it said, no, that he never touched me with that vibrator. And then seeing in the CAC, the fact that what happened on that four-wheeler, they had a rule. If she was driving recklessly, he would tell her to slow down. And when Holly Charlo is examining her on that, she gets to the buildup of where she is driving recklessly, and he has to hold on. He's in his 60s and bad health, has to grab something to keep from being thrown off. And the witness herself says she wasn't sure of his intentions. That's her testimony. Always, not only in that, but also in the defense deposition, defense A.
All right,
And so,
you're well into your rebuttal time. You got about 3:40 left. You want to save that for rebuttal?
I'll save it for rebuttal.
All right, great.
Thank you.
All right, Mr. Bradford.
Good morning. My name is Robert Bradford, and I represent the state of Florida in this matter. I'd like to begin by noting that there was reference made in the reply brief to the impropriety of the denial of the motion for new trial, as well as a claim of insufficiency of the evidence on the 3 counts for which the appellant was convicted. Those issues were not raised as substantive issues in the initial brief, and I would ask the court to disregard them as substantive issues in its consideration. With respect to the first issue, I think the issue is best restated as whether the trial court abused its discretion in following the law. For as long as I can remember, the proper procedure for impeachment by way of an prior inconsistent statement is that you direct the witness's attention to the date and location of the statement. You afford them an opportunity to admit or deny having made the statement. If they admit it, then they get to explain it as far as how, why the inconsistency. If they deny it, then you're allowed to offer extrinsic evidence as to the statement being made. And I believe in this case, the judge mentioned that if the victim denied making the prior inconsistent statements, that the defense could put forth the portions of the video in which the statement was made. That would be the extrinsic evidence. But as the court noted, the victim admitted on all occasions having made the prior inconsistent statement. I believe there was 8 different occasions in that first deposition, and she was asked about all 8 of them, and she admitted all 8 of them. In fact, other witnesses were even asked about the witness's prior inconsistent statements as well during trial. The appellant obviously downplays or disregards the significance of the victim having admitted that she gave conflicting statements while under oath on 8 different occasions. And in essence, what the appellant is trying to do is to bolster not the victim's credibility, but the victim's lack of credibility by presenting unnecessary and cumulative evidence where she had just admitted that under oath, she gave 8 false statements while under oath.
Well, you understand the counsel, you understand the logic of what he's saying. The jury is allowed to see her with the CP video, make the allegations that grandpa did all these bad things, and they can actually observe her demeanor as she's testifying. Unfortunately, or as the facts bear out, when it came to her recantation in the first deposition, they don't get to see her demeanor as she's testifying there, which, you know, may or may not really support the recantation. It may show somebody who's nervous and scared or whatever else, as I think may have been suggested. But I mean, logically, you understand that seeing her say at one time, grandpa did these things, seeing another time that grandpa showed me some cartoons, I think was about as worse as she got with the video of the depot. I mean, you know, it may have made an impact on the jury. I mean, logically, I'm not talking about what the legal requirements are and how it's been done for centuries, but you agree with the logic of his statement, don't you?
I can understand the argument, certainly. But now we're talking about the interplay between the admission of the child hearsay statement statute in connection with the impeachment procedure, proper impeachment procedure. In that regard, I think it behooved, and I was about to get to this anyway, I think it behooved the appellant to if that was the argument to make, then he needed to offer some scientific evidence or some expert testimony with respect to the jury, to today's juries, because this is the argument that he's making. Today's juries can't make a proper determination of credibility when they see video from one side without seeing video from the other side. And in that particular case, because they had the opportunity to gauge the victim's demeanor and her presentation when she was being cross-examined and when she was being rehabilitated on redirect. So therefore, there was that opportunity. They were deprived of the opportunity to see her reaction in video, but they saw her reaction at trial, both when she testified to the conduct, when she was cross-examined with having made the prior inconsistent statements while under oath. And of course, she was under oath there today, so that's as bad as you can get when cross-examining and impeaching a witness. And so the trial court didn't have the opportunity to make any findings of fact or make any conclusions of law with respect to the interplay of those two things, except that I'm going to follow proper procedure. And that's what he did. That's what the trial court did. And I don't think that appellant has shown that he was deprived of a fair trial, which is has to show in this particular case that it was harmful error. The abuse of discretion resulted in harmful error and prejudice to him and the deprivation of a fair trial. And that's simply not the case. Now, with respect to the lack of evidence, that kind of segues us into the second issue, which is whether the trial court erred in denying this trial based on the improper argument during the rebuttal closing. And I think it's important for the court to consider with respect to this issue that of both closings, both sides' closings, and the jury charge, according to the transcript, took about 3 hours. Defense counsel asked for an hour for his closing. I think the state probably took approximately about that with theirs as well. And it's also that during the initial closing made by the state, by the prosecutor, there were no objections made at all. Once you get into the rebuttal, that's when the objections were made, and that's when the improper comments are alleged. But if you consider each one individually, they were all, and consider the context in which they were made, I don't believe they rise to the level of an improper comment. First one, the fact not fiction comment. The prosecutor prefaced her entire rebuttal closing by saying, when I say fact, what I mean is facts admitted into evidence, testimony from the witness, exhibits admitted into evidence. She makes the age-old distinction in summations that lawyers have done forever, as far as I know, where they emphasize the strengths of their own case and the weaknesses of the other side's case. And that's exactly what the
Is it
prosecutor
proper
was
to
doing.
refer to the defense case as fiction?
In all candor, there may have been, a couple of choice words that could have been avoided. And in fact, when defense counsel complained, she did stop as far as using those particular words, the fiction word. But I think if you take it in proper context, because what she's saying is, when I say fact, she's emphasizing, I mean the facts that were admitted in evidence that are supported, not necessarily the unsupported arguments and red herring defenses. So another one was that counsel had used, when the prosecutor said the defense counsel had used recant as a buzzword. I'm not sure that statement is disparaging to me. I don't see the disparaging aspect of it, especially when you consider that it was made amidst an explanation that the recantation was not a true recantation, in the sense that the victim offered her explanation as to why she had made the 8 prior inconsistent statements under oath. And that was that, and this is a child, basically, what we're talking about. She was feeling overwhelmed by the whole process. She just wanted to avoid it. She wanted to ignore it. She wanted it to go away. And that's why she said that. And then she was deposed later because she decided, no, she can't do that. She needed to go through with it and see the prosecution to the end. And so so it wasn't a true recantation in the sense that it never happened. It's just that she testified that I just didn't want to deal with it anymore. And that's why I said what I did. So when the prosecutor said she didn't recant it, or she was being, it's a buzzword, that it was in that context. And again, in that context, the statement that the victim was truthful, again, maybe like with the fiction word, we're getting a little close there. Certainly an attorney can't vouch for a witness's credibility. I think that's certainly clear. However, the prosecutor made the statement in reference to the victims having admitted that she made 8 prior false statements while under oath. Not that the prosecutor vouched for the victim's credibility overall, but in consideration of, she gave you sworn testimony here today. She gave different sworn testimony in her first deposition. Yes, she did, but she admitted that. She didn't lie about it. She didn't try and hide it. She admitted it and she explained it. And that's the limited use of that word truthful to those particular prior inconsistencies. Could it make a better choice of words? Probably. Did it rise to the level of denying the appellant a fair trial? No. The conspiracy theory comment, again, made in conjunction with the defense argument that the Child Advocacy Center's purpose is to gather false accusations, frame innocent people, that sort of thing. It's not, it goes back to the lack of evidence. There was no evidence of that. It was simply argument. It was simply the speculation. So the victim, let's see. Oh, and being bound by the constraints of reality. In fact, again, in response to the argument of defense counsel that the vast government has unlimited resources. Okay, well, it certainly does have, certainly has resources, but they are limited. Can't create facts. They're bound by reality. And of course, she had just defined facts at the beginning of her thing, the witness testimony and exhibits admitted into evidence supported facts. Cited in my my answer brief, the Jones case was a second district case from 2002 that basically held that a mistrial should have been granted under the circumstances of that case. And I included it because that, I think, is a very good example of when prosecutors' comments rise to the level that a denial of a fair trial is inevitable. And these facts are just much more egregious than the facts we have in this case. In Jones, the prosecutor asked for sympathy for the victim, said that they only prosecute guilty people, associated the defendant with a criminal type, basically said that he was wasting everybody's time with the trial because we all know he's guilty, vouched for the credibility of his own witnesses, more than one, and also denigrated counsel and defendant personally. And that's the kind of thing where, you know, that would rise to the level of denial of a fair trial and the denial of abuse of discretion in denying the mistrial motion. So unless there are any further questions for me, I would simply ask this court to affirm the judgment and sentence.
All right, thank you. Mr. Hatfield?
Yes, sir. First of all, on this state attorney's rebuttal argument, the state was trying to reclassify what she had said and insisting it was not recantation. That she was apparently making a fiction of all that. But the manner in which she closed, she was a bulldozer in the case. If you read the transcript of record, she would interrupt the court, or if the court was going to caution her where she was clearly out of line in some of the matters, she would just cut the court off and then she would stop, but she would respond and cut the judge off. So just the manner of in which the rebuttal close was handled was inappropriate. As it relates to the admitted statements that—
Mr. Hatfield, you argue in your brief at some point that the court on these closing arguments cautioned the state attorney for the improper conduct. Where is that in the record? Where does the court caution her for something that was improper?
She never lets him get it out. As soon as he begins to argue to caution her, she just cuts him off and stops. I think the record shows that she went another page and a half and closed.
So the court did not caution her.
Well, he never got a chance. It was the manner in which it was done, Your Honor. It was a young prosecutor who was aggressive and wanted to win her case, but she—
Well, frankly, sir, I'm asking you about your comment in the brief where you specifically and affirmatively say that the trial court cautioned her for this improper conduct. I didn't find that in the record. I'm just asking if you have a cite to it. Now you're saying it didn't really happen.
The prosecution was never sanctioned by the court specifically at all. That was one of the problems, Your Honor, is that she pretty well ran the trial and was allowed to do that and stack and call witness after witness on child hearsay that was so cumulative that the court did comment on that and was concerned about it. And part of the record I cited in the brief, he was concerned about it was getting too cumulative. And so that's my answer to that, sir. That's the best I can do. I would say further that the witness, the complaining witness, child, had 30 days to fill out and think about what she was going to say in her statement as to whether anything was wrong with that deposition. And she made no attempt to clarify any statement in Defense Exhibit A that she had not been touched and that the testimony she had given in the Defense Exhibit A was in fact true and accurate. I think they word in the affidavit says accurate. So it just would appear to us that the defendant is entitled at least to a new trial But if it is remanded, there is also the option under Bieber, under Moore, under Green, for the court to remand it with instructions, which would mean that the court should dismiss the case.
All right.
There's no corroborating evidence.
All right. Thank you very much. And with that, we will be in recess.